Presentation today will be on how to handle a federal tax dispute, audit, appeal, and litigation. Okay, Lauren, you want to take it over?
Thank you for the introduction. I'm going to be discussing today what happens during an income tax audit and what are the taxpayers' appeal rights, both within the IRS and in the federal courts. Now, my first slide is an overview of what I will be discussing today, and it's color-coded. So the first row, which is in blue, that's the administrative level of handling the federal tax dispute, and we begin with the IRS audit, and then after that we would go to IRS appeals, and if nothing is resolved there, if there'd be a notice of deficiency issued by the IRS. And when the notice of deficiency is reached, the taxpayer has the option to file a petition in the U.S. tax court, or the taxpayer can pay the tax and do an administrative claim for refund, and then if that is denied by the IRS, then file suit for refund in either district court or the U.S. Court of Federal Claims. So those are the trial level courts that are in sort of purple color. And then say the taxpayer went to tax court and wants to appeal from there. They would go to circuit court, and that's the same with the district court. They'd also go to the circuit court for an appeal. And if the taxpayer is in the Court of Federal Claims, they would appeal up to the federal circuit, and then from the circuit courts, the appeal would be to the United States Supreme Court. All right, so now that we've gone through a quick overview of what we'll be discussing today, let's begin with the IRS's examination of returns. So returns may be selected for a variety of reasons, such as random selection and computer screening, a document matching program. That's when the information from a third-party document, such as W-2s and 1099s, don't match the information reported by the taxpayer. And also related examinations. That's when returns involve issues or transactions with other taxpayers, such as business partners or investors whose returns were selected for audit. So those are just some of the reasons why a return may be selected for audit. Now, what is an IRS audit? The IRS audit is the IRS's process for examining a return to determine its correctness. There are three main types of audits. There's an IRS office audit, and that's where the taxpayer goes to the IRS's office. There's a correspondence audit. It's when the IRS sends mail to the taxpayer for information. And there's a field audit, when the IRS official visits the place of business of the taxpayer. All right, during the audit, the taxpayer can act on the taxpayer's own behalf or be represented by a federally authorized tax practitioner, such as an attorney, a CPA, an enrolled agent, or an enrolled actuary. And if the taxpayer filed joint returns, then one or both of the spouses can meet with the IRS. To act as the taxpayer's representative, you must have proper written authorization from the taxpayer. And this is accomplished by IRS Form 2848, Power of Attorney and Declaration of Representative. And for married couples, you should use one form per person. And be sure to attach to the power of attorney any existing power of attorneys that the taxpayer does not want revoked when you file your power of attorney. All right, we're going to discuss attorney-client privilege. Now, this is sort of an advantage to using an attorney with the tax matters, because only an attorney can give the taxpayer the attorney-client privilege, meaning that the attorney is exempt from testifying against the taxpayer if the case goes to trial. In contrast, a CPA or tax preparer could be made to testify against the taxpayer. Now, while attorneys have the attorney-client privilege, there is a statutory tax practitioner-client privilege that's provided by Internal Revenue Code Section 7525A1. Yet this statutory tax practitioner client privilege is very narrow in scope, and it's entirely inapplicable to criminal tax cases. This tax advisor privilege, it applies only to the provision of tax advice. It doesn't provide any protection for the tax practitioner's work product, and it doesn't apply to written advice to corporate-type clients concerning their corporation's involvement in tax shelters. Now, there's something helpful called a Covell engagement. And now, a Covell engagement, this is something that originated in an appellate court case called United States versus Covell. And that's where a case where communications among the accountant, the attorney, and the ultimate client were protected from disclosure through an extension of the attorney-client privilege. So how does this Covell engagement work? Well, the attorney would retain the non-legal professional, such as a CPA, to assist the attorney in rendering legal advice to the attorney's client. And properly executed, the Covell letter engagement extends the attorney-client privilege to the CPA's work and communications. During the IRS audit, here's just a few tips on the audit. So during the audit, it's very important to keep copies and good records of what you provide. And it's a good idea to ask the IRS for an audit plan and timetable. Ask the IRS to submit their information or its information requests in writing. Those are known as information document requests, IDRs. And when responding, be as brief as you can. Don't volunteer information that's not requested. If you don't open a door, they can't go through it. And also very important, do not give original documents to the auditor. Keep your originals and give copies to the auditor. Because if the auditor loses that original, you don't have it anymore, it could become a real problem for the taxpayers, especially in a substantiation case. You no longer have the document, because that's not a good enough excuse. So be sure to not give your original documents away. Now, to preserve privilege or protected information from documents, the taxpayer should decline to disclose the privileged material and instead submit a privilege log. The log should state the privilege or protection being claimed and describe the material that, without revealing the information, allows the IRS or court to assess applicability of the claimed privilege or protection. All right, let's say now we're at the end of the audit. So what are some of the results of the audit? And I broke it down into 4 different types of results of the audit. The first would be a no change audit. And that's where the IRS accepts the return as filed, and the taxpayer would get a no change letter stating the examiner proposed no changes. And that's a great result. So I wrote, yay, yay, a no change. Now, a second type of result, which is even better, that would be where the taxpayers do a refund and gets interest on the refund. Woohoo, now that's great, really great. All right, a third type of result would be an agreed result with the audit. And that would be where the IRS proposed changes and the taxpayer agrees with the changes. Now, if money is owed, there are several payment options available, such as paying in full, or setting up an installment agreement, an offer in compromise, taking out a loan. There's several different payment options. Now, a fourth type of result of the audit would be a disagreed audit. And that is where the IRS proposed changes and the taxpayer disagrees with those changes. Now, when the audit ends as disagreed, the IRS will issue a notice to the taxpayer called a 30-day letter, stating the findings of the examiner and the taxpayer's appeal rights. Note that this 30-day letter could also be received by the taxpayer if the taxpayer ignores the IRS audit notices. All right, so now we're moving on to the administrative appeal within the IRS. And that is, again, with the 30-day letter. And the 30-day letter is a pre-assessment letter. It informs the taxpayer that a deficiency is being proposed and notifies the taxpayer to begin the appeal process within 30 days or pay the tax. Now, to appeal the examiner's proposed adjustments, the taxpayer has 30 days within which to file a protest requesting a conference with the IRS Appeals Office to discuss the disputed issues. If the taxpayer does nothing in response to that 30-day letter, then the IRS will issue a 90-day letter, also known as a statutory notice deficiency, a NOPA or a stat notice or a SNOD. That I'll discuss the 90-day letter a little bit later in this presentation. Now, note with the 30-day letter, since the 30-day letter is an administrative letter and not a statutory notice, the IRS may grant the taxpayer's request for an extension of time to reply. All right, let's take a moment to discuss the statute of limitations for assessment. Now, the IRS typically gets 3 years from the date the return was filed to make an assessment. And there are 6 years in the case of a substantial omission. And that's where there's an omission of 25% or more of gross income stated in the return. And the statute of limitations is unlimited for unfiled or fraudulent returns. Now, the assessment period can be extended by agreement between the taxpayer and the IRS. If only legal issues remain in dispute, then to me it doesn't make much sense to extend the statute of limitations. However, if there are factual issues, for example, substantiation issues, then extending the statute of limitations might make sense. And that's so the taxpayer would have time to gather the documentations and information that are needed to substantiate whether it's like, for example, the expense, to show the receipts. The taxpayer would need time for that. And if you need the time for that, then maybe the extension makes sense. All right, so here's a slide just to help you with distinguishing between factual and legal issues. Now, to distinguish between factual and legal issues, if you ask where you must look to reach a conclusion. Now, if you consult only the law, then the issue is legal in nature. Otherwise, it's a factual issue that must be resolved through gathering additional information. So again, the tip on distinguishing between factual and legal issues is ask where you must look to reach a conclusion. If the taxpayer does not respond to the 30-day letter or is unable to reach an agreement with the IRS Appeals Office following a protest, or the statute of limitations is about to expire, then the IRS will send the taxpayer a statutory notice of deficiency, commonly referred to as a 90-day letter. The statutory notice deficiency, or stat notice, is the ticket to tax court. It gives the taxpayer 90 days within which to petition the U.S. tax court to redetermine the liability that is proposed by the IRS. Now, there is a small exception of 150 days if mailed to the taxpayer outside the U.S., but it's better to think of it as 90 days because this is not a deadline that you want to miss, usually. Now, since the 90-day period is prescribed by statute, it cannot be extended. During the 90-day period after the statutory notice deficiency is issued, the IRS is barred from making an assessment or collection activity. And if the taxpayer files a petition with the United States Tax Court, this continues until a U.S. Tax Court decision is final. It's very important to remember that the failure to file a timely petition with the tax court will result in the deficiency being assessed by the IRS. All right, now we're going to be discussing appeals to the federal courts. So this would be in the third row of that overview, or actually the second row of the overview. That was on slide 2. So appeals to the federal courts are known as judicial review, and the taxpayer may request judicial review of IRS determinations by filing a petition with the U.S. Tax Court, the U.S. District Court, the U.S. Court of Federal Claims. And these three courts are independent of the IRS. The U.S. Tax Court is a federal court of limited jurisdiction established by Congress under Article 1 of the U.S. Constitution. Its jurisdiction includes redetermination of deficiencies in income, estate, and gift taxes, interest abatement cases, worker classification cases, collection due process cases, and innocent spouse relief. The U.S. Tax Court is located in Washington, D.C., and the judges travel around the country to designated cities to hear cases. Now, the U.S. Tax Court does not require the taxpayer to first pay the amount in dispute in order to file suit. And this is why the U.S. Tax Court is often a first choice for many taxpayers. In tax court, there are no jury trials. The case is tried before a single judge with expertise in federal tax law. And the U.S. Tax Court has its own rules and procedures that supplement the federal rules of civil procedure. And the IRS is represented by IRS counsel, except for the S cases that I'll discuss later, the tax court decisions can be appealed to the appropriate circuit court. All right, now we're going to discuss the U.S. Tax Court judges. There's three types of judges. There's regular judges, and those are the 19 regular judges appointed by the President after confirmation by the Senate for a term of 15 years. There are also senior judges. Those are the same presidentially appointed judges who have reached the mandatory retirement age of 70 and are recalled by the chief judge to assist in disposition of cases. The third type of judge is called the special trial judge. And special trial judge is equivalent to the magistrate judge in federal courts, and they serve at the discretion of the chief judge. And it's important to note that an advantage to the tax court route is that a case petition to the U.S. Tax Court will generally be considered for settlement by an IRS appeals officer before the tax court hears the case. However, since the case is on the tax court docket, it will be a docketed appeal, meaning any settlement will need to be approved by IRS counsel. There's something called the Golson rule in tax court. Now, under this Golson rule, the tax court is bound by the precedent of the circuit court in the geographic jurisdiction in which the taxpayer is located. This means that the tax court must follow the precedent of the circuit court to which the appeal would lie. Thus, sometimes the tax court will reach different rulings for different taxpayers on the same facts. Now, I'll give you an example. So here's a map of the federal circuits. Now, if there's a split in the circuits, and the taxpayer is domiciled in San Francisco, which is in the Ninth Circuit, over there on the left in yellow, then the tax court would have to follow the law in the Ninth Circuit. So I think that example was good, but just to clarify a little bit more, what I mean by split in the circuit is say there's a different law being applied in the 10th Circuit, which is blue, and in the Ninth Circuit, which is yellow. And then our taxpayer lives in the Ninth Circuit, then the tax court would have to apply the law of the Ninth Circuit. Even if the case is held in Texas or in Florida, the court would still have to apply the Ninth Circuit law. Okay. For tax disputes involving $50,000 or less for any 1 year, the taxpayer may elect to have a case designated as a small tax case or S case. Now, these S cases are heard by special trial judges. They're less formal procedure than regular cases. And what I view as a big disadvantage is that the decisions in S cases are final and they're not appealable. Okay. Now, in going with the U.S. Tax Court route, It's important to remember that the statutory notice deficiency or 90-day letter has a presumption of correctness. So the taxpayer generally has the burden of proving that the IRS's determination in that notice deficiency is improper. And so the taxpayer generally has the burden of proof. This means that if the taxpayer and the IRS go into tax court with nothing, the IRS wins. Now, the burden of proof, it can shift to the IRS in limited situations. And also, the burden of proof, it rests with the IRS as to any new matter, increases in deficiency, affirmative defenses such as statute of limitations, and fraud, which has to be shown by clear and convincing evidence. In tax court, the case is commenced by the filing of a timely petition. Also, a $60 filing fee, a statement of the taxpayer identification numbers, which would be the Social Security number or employee ID number, and also a request for a place of trial, deciding or requesting the city for the trial to be held in. And there's a list of cities that the tax court goes to, and that list is easily available on the tax court website. And also for certain taxpayers, an ownership disclosure statement would also need to be filed. When you file the petition, be sure to raise any affirmative defenses in the petition, if there are any, such as statute of limitations, so that they aren't waived. After the petition, the IRS answer, and if required, the taxpayer's reply are filed. The case is considered at issue, and pretrial discovery can begin. Now, this is typically where the IRS administrative file for the case is sent back to IRS Appeals Office to be considered for settlement. Okay. The tax court rules permit the IRS to amend its answer when justice so requires. Now, this is applied, from my experience, this is applied very liberally. For example, in one of my cases, the IRS amended its answer to concede an NOL, a net operating loss adjustment, and alleged a new $1 million plus adjustment that was based on an assignment of income theory. And they did this about a month prior to trial, and the court allowed them to do so. And I think that I recall the court saying it wasn't as if we had a summary judgment motion pending. And then in another case, we actually had a summary judgment motion pending, and the government was allowed to amend its answer again. And so this standard of when justice so requires, it's applied very liberally. And that when the IRS amends its answer, that's when they're adding in a new theory or raising the amount at issue. So here's a tip that if there's lots of messy and potential tax issues that are not raised in the statutory notice of deficiency, and the taxpayer can afford to pay the amount at issue in the statutory notice, then it might be a good option to let the 90 days lapse so that the statutory notice of deficiency becomes final, and then have the taxpayer file a timely claim for refund that's limited to the adjustments in the stat notice. And timing with this is very important because otherwise the IRS might be able to bring in new tax issues. And also, the IRS still can bring in matters for offsetting, because in the refund case, the IRS just has to show the taxpayer should not get that refund. All right, going back to the amended answer, the burden of proof on any new matter or increase in deficiency that is raised in the amended answer falls on the IRS. Now, this isn't as big a deal as it seems, though, because the standard is reasonableness, and that's a pretty low standard. And another example I would give would be I had a case that had a bunch of factors that were being applied by the court, and say there were 7 factors, and there were 4 tax years at issue. Actually, there were 3 tax years at issue, and in one of the years, the burden was on the IRS. Now, when the court went through all these factors, they decided that 7 factors were in favor of the IRS and 5 were in favor of the IRS and 2 were neutral. Now, I would have thought that since the burden of proof was on the IRS for one of the tax years, that the taxpayer would have at least won the factors that were decided to be neutral, but we didn't. And that's just an example of how the reasonable standard is very low. Okay. So now say we're in U.S. tax court and it's with pretrial discovery. And it's important to, or an important part of tax court is that the tax court rules reflect an abbreviated discovery process and a strong preference for stipulation of facts and documents, and a desire to reduce the burdens and expenses associated with litigation in other forums. So the tax court expects parties to engage in informal discovery prior to using any formal discovery procedures. All right, say that the taxpayer doesn't go the tax court route. What else is available? So the taxpayer can challenge the IRS determinations in a U.S. district court as well. But there's a procedural prerequisite. The taxpayer must first pay the disputed tax liability and file a claim for refund of the tax paid prior to filing the lawsuit. And in U.S. District Court, the taxpayer has an option for a judge or a jury trial. Whereas, remember, in tax court, there's only one judge. There's only the judge sitting on the case. So in district court, you do have the option for a judge or jury trial. And the district court is bound by the legal precedent in the geographic jurisdiction of the taxpayer, and appeals from district court are made to the circuit court in the geographic jurisdiction of the taxpayer. Generally, the taxpayer must file the claim for refund within 3 years from the date the original tax return was filed, or 2 years from the date the tax was paid, whichever is later. Generally, the taxpayer must file the suit for refund no later than 2 years after the IRS has rejected the claim. However, the taxpayer can file suit if it has been 6 months since the refund claim was filed and the IRS has not yet delivered a decision. The third venue for judicial review would be the United States Court of Federal Claims. Now, the Court of Federal Claims is a court of limited jurisdiction created by Congress under Article 1 of the U.S. Constitution. So it's similar to the tax court, which is also created under Article 1 of the U.S. Constitution. Now, you recall, or going back to history classes, and you may have taken growing up, college, high school, or something in law school, that with there's the 3 branches of the government, and there's Article 1, 2, and 3, and most courts are Article 3 courts, and that's like the district court, for example, and those are in the judicial branch. And so the tax court and the Court of Federal Claims, those are created under Article 1 by Congress, and that's why their jurisdiction is limited. And in the Court of Federal Claims, there's no jury trial, and similar to tax court, the taxpayer must first pay the disputed tax liability and file a claim for refund of the tax paid prior to filing the lawsuit. The Court of Federal Claims is bound by precedent of the former Court of Claims, the Federal Circuit, and the United States Supreme Court. Appeals go to the Federal Circuit. And a special rule with the U.S. Court of Federal Claims is that the taxpayer cannot file a suit in the Court of Federal Claims if the taxpayer's claim is for a credit or refund of a penalty that relates to promoting an abusive tax shelter or to aiding and abetting the understatement of tax liability on someone else's return. All right, now I'm going to take you back to the first, or to slide number 2. It's not working. I'll just go this way real fast. It's not working. Oh, here we go. We'll just go this way. Got it. All right. So back to the overview slide. So here's an overview again. I'm going to walk back through it now that we've gone through this. And so now the case began with the IRS audit, and I gave you some tips on that audit. For example, don't give away originals, ask for requests in writing. And then if nothing's resolved at the IRS audit level, the tax, or possibly the IRS, if the taxpayer doesn't respond to the IRS's audit notices, then there'll be a 30-day letter, and the taxpayer has 30 days to file an appeal with IRS Appeals Office. And if nothing is resolved there, or if the statute of limitations is about to expire, then a notice of deficiency, the 90-day letter, will be issued. And then at that point, the taxpayer can decide if they want to pay the tax and do an administrative claim for refund. Notice how we're still all in the administrative line at this point. And then if they do that claim for refund, then, and if the IRS rejects it, or if the 6 months go by and they haven't acted on it, then the taxpayer can file suit for refund in either district court or the Court of Federal Claims. Now, with the notice of deficiency route, if the taxpayer gets that notice of deficiency, they have 90 days to petition tax court. So say they petition the tax court, and now those are the 3 venues to appeal the IRS determination. Now, appeals from the tax court and the U.S. District Court would go to the appropriate circuit court, and appeals from the Court of Federal Claims go to the Federal Circuit. And then from the circuit courts, the taxpayer's appeal would go to the United States Supreme Court. Went the wrong way. All right, so thank you very much for attending, for watching this webinar, and I hope it has been very helpful. And if you have any questions, please feel free to contact me at Royce Law Firm, and my contact information is on the page 1 of this presentation. So thank you.